my topic is organizing documents, and so that's pretty much what I'm going to talk about. But I do want to make a few other observations, and the first thing I need to do is the same thing our friends from Roger Williams did, which is to say that I am a lawyer, but I am not your lawyer. Why? Because we do not have an attorney-client relationship by virtue of this conversation that we are having. And it's very important for you to understand that if you're going to go out and do things on planet Earth that have consequences for you, you are well advised to enter into an attorney-client relationship with an attorney who can provide you with advice that is key to your specific situation, because every situation is going to be different. My second thing that I have to say, by way of a confession, is I am really into cooperatives. My bias, personally, because of my personal values, strongly favors incorporating businesses, particularly worker-owned businesses, as cooperatives rather than any other kinds of entities that are available. And I have LLCs are more flexible than corporations in general. That's sort of why they were brought into existence. But you might not want that much flexibility. You might very well want to enshrine certain things in your organizing documents that your successors can't change based on whim or just changing notions about what's right and good about the entity that you're creating. So I have studied the Massachusetts Employee Cooperative Statute, and it was written not by a bunch of legislators, but by people who were really thinking about cooperatives, including the dean of my law school, so that gives me another bias in favor of it. And so I think that if you are here in Massachusetts, you should seriously consider incorporating, if you haven't yet, under the Massachusetts Employee Cooperative Statute. I should also say that you are not obliged to incorporate in your home state. You can incorporate in any state you want. I don't recommend it. And that's another one of those subjects that's, I think, a little too out there for the present purposes. I mean, if you're curious, I'd be happy to tell you why I think that's a bad idea. But just so you know, you can. You know, a lot of people incorporate co-ops in Minnesota because Minnesota has a lot of co-ops, and so a lot of established co-op law and a very well-developed cooperative statute. Your organizing documents are best thought of as a hierarchy. Each step in the hierarchy yields to the items in the hierarchy that are above it. So looming over all of this is the statute, meaning the law that a legislature has passed, under which you decide to incorporate. So if you incorporate as an LLC in Massachusetts, your business is governed by the Massachusetts Limited Liability Corporation Act. And if you incorporate in Massachusetts as an employee cooperative, you are governed by the Massachusetts Employee Cooperative Statute. And it's there. The only way to change, it's very hard to change, because the only way to get that to change is by having the legislature pass a bill and having the governor either sign it into law or veto it and have his veto overridden. That's difficult. Below that is a document called Articles of Organization. That's what they're called in the co-op statute. Sometimes they're called Articles of Incorporation. And this is a document that you have to write up and file with your Secretary of State, who is a state bureaucrat, and his corporations division will read your Articles of Incorporation and decide if what you have put in them is consistent with the requirements of the statute under which you're incorporating. And if they decide that they are, they'll put a little stamp on them, give you a certificate of incorporation, send it back to you, and you have become an entity. And as our friends from Roger Williams just told you, that is the gift that keeps on giving. I mean, when the government hands you that piece of paper that says you have limited liability on it, you have just gotten a free ticket to commit all kinds of crimes and misdemeanors without being personally liable. The most you can lose is what you have invested in your corporate entity. That's true for any kind of entity. You know, you hear people rail all the time about corporate personhood. I'm here to say corporate personhood is actually a good thing. In fact, we would be well advised to take it even farther than we already have taken it, because one of the problems about corporations is they have perpetual existence, whereas people can't live forever. And there's a bunch of other things that we could say about that, but rather than use up all my time talking about corporate personhood, I will say that what is typically in articles of organization that you file with the Secretary of State to form a worker co-op are the name of your business, some statement of what purposes you have incorporated the business for, and as far as I'm concerned, the more general that you can be about that, the better off you are. You know, it might be that your worker co-op or your employee co-op is into giving people rides, right? Because it's got little cab things that you guys pedal around. But you might decide 5 years from now that your employee co-op also wants to sell ice cream on the side, because it turns out your cab customers like to eat ice cream while you're pedaling them around. You wouldn't want that to be inconsistent with the statement of purposes in your articles of organization. That would create trouble. The other thing that your articles of incorporation has to talk about is how much stock you're authorizing the entity to issue, whether there are different classes of stock, and in worker co-ops you are allowed to have 2 different classes of stock, and who the initial directors of the organization are. So basically the people who are starting the co-op have to identify themselves and list themselves on the articles of incorporation, and you file that with the Secretary of State, and you exist. You have come into existence. The articles of incorporation say very, very little about what you're going to be doing together. Below the articles of incorporation are your bylaws, and your bylaws, I think, are the most important document that you create. That said, what I like to say about bylaws is they are not the Declaration of Independence, they're the Constitution. And by that I mean, if you read the Declaration of Independence, have most of you read it? There is a lot of rhetoric and statements of values and principles and aspirations in the Declaration of Independence. How many of you have read the US Constitution? In the Constitution, if you actually go through, and it's an app, by the way, I have it on my phone. If you read the Constitution, there's very little in there. There's a preamble that says, we the people, blah, 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 blah. But if you really get into the document, it's really about the mechanics of how our country is set up as an entity. That's exactly the same thing as bylaws. Even though I believe passionately in the cooperative values and principles, I don't advocate putting a lot of that stuff in your bylaws because they simply create confusion and ambiguity. If you want to say in your bylaws, we aspire to adhere to the cooperative values and principles, by all means do that. But mostly what your articles or your bylaws are focusing on are the mechanics of how you are going to govern yourself as a business. So what do I mean by that? Well, who are the members of your co-op going to be? There should be a whole section of your bylaws that just talk about who the members are, what kind of stock they're going to own, how membership is terminated, because that will happen, whether the shares are transferable, and I think that what you want to do in your bylaws is make your shares non-transferable, for a reason I'll explain. And you also want to talk about what's going to be in the certificates that you issue that are essentially the pieces of paper that tell people that you own shares. You also, I think worker co-ops are well advised to set up a internal capital account system. This gets into subchapter T stuff.
Can you say that again, that last piece?
How far back do you want me to go?
After, are the shares transferable and better not, and then the...
Let me back up and say that in American law, as far as I know, there is no state that really defines what a cooperative is fundamentally. The place in American law that really drives the difference between cooperatives and other kinds of businesses is the Internal Revenue Code, subchapter T, and you want the favorable tax treatment that subchapter T provides you. And it's around avoiding double taxation and also having the flexibility to decide whether you want to keep your profits at the corporate level and have them taxed and then consider distributing them. You can do them either way. The terminology is a little different than in subchapter T. You talk about allocated or qualifying versus non-qualifying and allocated versus non-allocated. But the principle is the same. It's about avoiding the double taxation if it's appropriate for you, given the way your business operates and the way your CPA tells you that you will end up with the lowest amount of tax liability because that's the reason why it exists, isn't it? To pay as few taxes as possible. And so in order to qualify for the favorable treatment that you get under subchapter T of the Internal Revenue Code, the IRS, through case law, has basically decided that you have to be doing three things, right? Thing number one, subordination of capital. I'll give you my business card, by the way, this is on the back of my business card. That means that basically your business doesn't operate to provide profits to outside investors. That's what subordination of capital really means. Thing number two, one member, one vote. So ExxonMobil or BP or Apple or Chevron or Monsanto, you know, those corporations are all organized so that it's one share, one vote. So if you own 1 billion shares, you get 1 billion votes. If you own one share, you get one vote. At a co-op, doesn't matter how much money you put into the corporation, you are one human being, you get one vote. That's key. And then the third thing that you have to do in order to convince the IRS that you're operating on a cooperative basis is distribute your surplus according to patronage. And patronage is the most important word in the law of cooperatives. It's also, as I said earlier, the reason that the Rochdale Cooperative succeeded where every other cooperative that came before it didn't succeed, meaning last. Because it turns out that the Rochdale pioneers, meaning the people in 1844 who formed a cooperative in Rochdale, England, sitting around a pub, they figured out that this allocating of surplus according to patronage, basically how much you put into the co-op, is the fairest way to divide up your profits. And people felt comfortable with that. That co-op lasted. That has persisted through the years so that when the IRS thinks, is this really a cooperative? It doesn't look to what statute you're incorporated under, although that's relevant. It doesn't care what your bylaws really say. It cares about whether you're operating on a cooperative basis. So what you want to do is get things into your bylaws that will make the IRS think these people are operating under a cooperative basis so that you don't have any trouble with the IRS. So I mentioned an internal capital account system. There are really two things that you can do with profits if you're a co-op. You can pay them out and write your members a check, that's patronage, or you can keep them and reinvest them in the company, but you can allocate those patronage surplus to the members, and you do that by keeping the money in an internal capital account, and each member of the co-op has a little sub-account in that account, and then you get a piece of paper from the co-op called a written notice of allocation that says to the members, by the way, we're allocating that tax liability to you, not the co-op, even though we haven't paid you the money. You're looking puzzled.
Well, it's a lot. And I'll get you a business card.
Okay. So your bylaws need to talk about when the members are going to have meetings. Will they have an annual meeting? They should. Are there circumstances where you're going to call a special meeting? Something happens. The members need to get together and talk about and vote about something. When are you going to do that? What kind of notice are you going to need to give each other when you're going to have a meeting? Because you don't want, you know, these folks over here who are secretly trying to do something that these folks over here don't like. You don't want them to call a meeting, declare that there's a quorum, and then vote all of you people out of existence, or vote to do something bad, like start selling ice cream when the people over here think that ice cream, because it's milk out of cows, is evil. So you want to know what the notice requirements are. You want to create a board of directors. How big is it going to be? How long are the board of directors members going to serve? Are there going to be term limits? How are they removed if they do something wrong? What process is there for getting them out of there? Are there circumstances when the board can act simply by having everybody agree to do something without actually having a meeting? Then you want to say in your bylaws how the board of directors is going to be governed, right? Will there be officers? Usually boards of directors have a chair, a vice chair, a secretary, and a treasurer. That has to be in the bylaws. Most bylaws, you're well advised to do this, have a provision in it called indemnification. And what that says is, if you serve on the board of your co-op, either an employee co-op or otherwise, and somebody comes along and sues you and accuses you of having done bad stuff as a director, the co-op agrees to indemnify you, basically pay whatever legal liability you incur, because you shouldn't agree to serve on the board of directors of anything unless the organization is willing to indemnify you. You shouldn't be exposing yourself to personal liability just by participating in the governance of your co-op, because that's what limited liability is all about. You don't want to relinquish that just by joining the board of your co-op. That's what an indemnification provision does. And then the bylaws also want to specify how you amend the bylaws. In some circumstances under Massachusetts law, it is legal to authorize the board of directors to amend the bylaws, and in some circumstances it requires a vote of the membership, meaning the owners, to amend the bylaws, and you can specify supermajorities for amendments if you want to. It's really all about what degree of flexibility you want when you organize your co-op. What's beneath the bylaws? Well, if you're a worker co-op, you can create operating procedures and policies and things that will govern how your cooperative works as a workplace, because on top of all the such stuff, it's also a business that has to operate and do stuff and have rules about when people are going to come to work and how many weeks of vacation they're going to get, and whether they're going to be nice to each other in the workplace and all of that stuff. That's stuff that you can put in your operating rules, and then there's everything else that a business does. So I think that's my 15 minutes. Did I forget to tell you anything? No.
Great. So, thank you. That was really clear. And
I have a question.
are there any questions for that are pertinent to the whole group before we go into dinner and then small groups?
I have a lot of questions. I guess one really specific one is just about patronage. And is patronage like essentially, or in essence, defined by like how many hours you put into the co-op? Because
that's a great question.
I'm curious about the one member
So,
versus.
patronage is, if you talk to lawyers, they will tell you that patronage is a legal term of art, meaning it has this very complicated meaning depending on the situation, and that meaning isn't necessarily obvious to the non-lawyers. It's one of the ways we lawyers lord it over the rest of the world. So patronage in a consumer co-op, meaning like a food co-op, is how much business you do with the co-op, how much stuff you buy. Patronage in a housing co-op is usually how much housing you occupy. At an electric co-op, it's how much electricity you use. If you're running an ag co-op and everybody's producing milk and sending the milk to Agrimark, it's how much input, how much product you feed into the co-op. And at a worker co-op, it's usually how many hours you put in. But the reason I'm hedging is, I'm 56 years old and I am an old, wise, experienced guy, right? And you're probably 10, 15, 20, 30 years younger than that. You're just starting out. We're both members of the co-op. We might agree that my labor is more valuable than yours in terms of an input, and we might want to value my patronage more highly than yours. That's permissible. Or we might want to measure our patronage by some other measure than just hours, particularly if we're all professionals and we're not working on an hourly basis, we're working on a salary basis. So that's something to hash out in your bylaws, because that's a pretty important thing.
So that's where you decide if it's like a scale.
Right, exactly. And it's a matter of judgment, right? How much of that do you want to lock in so that it can only be changed if you amend the bylaws, versus how much of that do you want to put in your operating agreement that is much easier to change? And the only thing you can't do is adopt something that is either inconsistent with your statute or makes the IRS think that you're not a co-op.
Great. So I think,
So the patronage.
Last question.
So the patronage is not necessarily based upon sweat equity. It can be knowledge level.
Those things can affect the amount of patronage, but as a general proposition, your garden variety employee co-op, it really is a matter of how many hours you work, because that's fundamentally fair. And I would think for most of you, from what I've heard about the kinds of co-ops you're starting, that's probably the way you want to do it, at least at first. So I'm all about incorporating co-ops, because I think, LLCs are new, right? They were invented, 15 years ago, something like that? you know, the different kinds of modern business corporations, I mean, you know, those have succeeded in sinking the economy several times over. Co-ops have really existed in their present form since 1844. They are the second success story of the world economy. And they are as tried and true a form of doing business as any that exists.
Plus you get
1844 in
movement
this
credibility.
country?
if you
Well,
choose.
you get that.
Sorry, in this country, 1844, what was
Well, they started in the first co-op that persisted was the Rochdale Cooperative, and it was founded in 1844.
But that was in England, right?
Yes.
What was the first co-op here, do you know?
Oh gosh, I don't, but I know that cooperatives came to the U.S. through immigrants from Finland, from the Scandinavian countries. They tended to settle in the Midwest, like in Minnesota and Wisconsin. That's why you have a ton of co-ops in Minnesota and Wisconsin, even though I respectfully suggest that on a per capita basis, the cooperative state, Vermont.